Hello, welcome to today's webinar, Hot Topics in Directors Liabilities. My name is Stephen James. I'm a partner at Clark's Legal. I specialise in dealing with commercial disputes and sometimes ones that have an insolvency element. Often the issue of directors' liabilities, directors' duties come up, and sometimes it's argued that director should pick up the liabilities of a company. In today's session, I'll be building upon the webinar that we gave a little while ago entitled Directors, How Limited is Your Liability? If you want to see that webinar, it's up on our website. If you go to the Legal Updates page and click on Webinars. That webinar, we talked in a more theoretical sense about how directors can face liability. And in today, I'll be giving some practical examples as to how those liabilities play out in practice. I'll be talking about 7 or 8 examples that the courts has had to consider in the last year, and drawing some lessons from those, and what the implications will be for directors. So, what are my duties, and more importantly, who is a director? Without going over the law too much, a director will be someone who's properly appointed at Companies House, what we call a de jure director. But importantly, also covers what are known as shadow directors, someone who sits in the background and pulls the strings, although they won't officially be on the books as a company director. Directors' duties over time typically are referred to as fiduciary duties, and they evolved over many years through case law. But in the 2006 Companies Act, those duties were codified. And I'll just run through them quickly before we get on to the cases. The first one is to act within powers of the company. Directors have to do only what's allowed under the company's constitution. This is a subjective test. The director's motivation is examined, and what was the reason behind whatever they did. The next one, under section 172, I'll be covering a bit more detail later to promote the success of the company, and that's determined with reference to quite a few different factors. The likely consequences of a decision on a long-term basis, the interests of the company's employees, the need to foster the company's business relations with its suppliers, its customers and others, the impact of the company's operations on the community and the environment, desirability of the company maintaining a reputation for high standards of business conduct, and a need to act fairly between shareholders. There's also sometimes the need to consider the interests of the company's creditors, and that kicks in when the company gets into financial difficulty, and that's something I'll be talking about in a little more detail later on. Next one, under section 173, is duty to exercise independent judgment. Directors, of course, can and should take advice where appropriate, but ultimately the buck stops with the director, and they must make their own decision. Section 174 is to exercise reasonable care, skill and diligence. This is judged objectively and subjectively. There's a minimum standard that all directors will be judged by, but if a director has any particular skill or qualifications, there's a higher standard expected of them to take that into account. To avoid conflicts of interest is fairly self-explanatory. Section 176 covers not accepting benefits from third parties. That's something you might receive purely because you are a director, rather than anything you've actually done to deserve it. It's the kind of thing, as a rule of thumb, I would say, if something feels wrong, it probably falls foul of the Companies Act duties here. And the final one is to declare an interest in proposed transactions. So getting into the cases I want to talk about, and the first 3 will cover breaches of these duties. And the first case is Richard Hunt Investments Limited and Richard Hunt. Now, this concerned a plumbing training business, and there were two companies, and Mr. Hunt was a director of both of them, BTSC and RHIL. Unfortunately, they both went into liquidation. And around about the time of the company getting into trouble and following the liquidation, Mr. Hunt did some work to renovate premises to allow one of the companies to continue running its plumbing training courses, which ultimately was to benefit of the company, reduce the value of the claims, and reduced its liability to creditors. And in the course of that, Mr. Hunt was responsible for organising some fairly substantial payments from one company to the other, from BTSC to RHIL, and then some further payments from RHIL to Mr. Hunt personally. Now, you won't be surprised to learn that some claims followed from this. BTSC's liquidator claimed that Mr. Hunt was guilty of misfeasance. Misfeasance is something that's available to a liquidator under the Insolvency Act. Essentially, if a director has breached his or her duties in some way, it may constitute misfeasance. So the liquidator brought this claim against Mr. Hunt, and the claim settled. Then the other company's liquidator, who was actually the same person, same individual, claimed that the second set of payments, and these were the ones by RHIL to Mr. Hunt personally, were made in breach of trust, and they should be repaid. Mr. Hunt admitted receiving the payments, but he said he shouldn't repay them because he should have relief under a section of the Companies Act, section 1157. And I'll take you through what this says, and it's rather long, so I'll take it slowly. If there is a claim against an officer of a company, against a director, for negligence, default, breach of duty, or breach of trust, well, at least a couple of the boxes there were ticked for the claim against Mr. Hunt, so this was engaged on its face. It appears to the court hearing the case that the officer or person is or may be liable, has acted honestly and reasonably, and in regard to what his circumstances, he should be let off. So breaking it down, there's some primary liability potentially, but the director has acted honestly and reasonably, and that means that the director should be excused. So could Mr. Hunt have the benefit of this? Well, the court decided that the test of honestly should be judged subjectively. And in the circumstances, Mr. Hunt did act honestly. He did the work to allow the business to continue running the courses, which ultimately reduced the value of the claims. So he wasn't lining his own pocket. He was acting honestly. However, the test of whether he acted reasonably should be judged objectively. And in the circumstances, he didn't act reasonably because he wasn't doing what he did with the liquidator's express knowledge and approval. Although it benefited the company, he wasn't directed to do this by the liquidator. And secondly, he'd not kept a proper record of what he was doing. The court had to consider whether the value of the money, the money he'd received, was fair value for the work that he had done. It was all undocumented. The court was unable to give a proper valuation to the works, and for that reason, Mr. Hunt couldn't take advantage of the Companies Act exemption, and he was in fact ordered to repay £290,000. So, what lessons can we learn from this? Well, firstly, that it's very important to remember that company funds are company funds and personal funds are personal funds, and often where I see cases where directors in particular have run into problems is where they've failed to keep that distinction. They treated the pots of money as interchangeable, and they've moved from company to personal, as Mr. Hunt did do here. And the second issue, it emphasises the importance of directors keeping records, documenting what they're doing and why they're doing it. it sounds like reading the judgment, had Mr. Hunt done so and kept a careful record of actually what he'd done, how much that was worth, it would have been much easier for the court to allow him to benefit from the Section 1157 Companies Act exemption. The next case I want to mention, again on the fiduciary duties theme, is one called Buller and Buller. This is there's actually a lot of litigation involving the Buller family, and this is the latest chapter in the saga. There were two brothers, Jat and Inder, who are directors and shareholders of two companies, BBL and BDL. In addition to this, Jat set up a third company called Torex, and he caused the two other companies, BBL and BDL, to make some large payments to Torex. Unfortunately, Torex went bust, and it left more than £800,000 owing to BDL and BDL. Now, Inder wanted to get the money back, but he had some problems. BBL and BDL, of course, had a claim against Torex to be repaid the money, but Torex had gone bust, so there was no point suing it. And also, Jat, who partly controlled BBL and BDL, didn't want to bring the claim, and Inder didn't have sufficient control over the companies to make that decision on its own. There's actually a third problem, was that many of the payments were made more than 6 years before the claim was issued. And the general rule for civil litigation in England is that there's a 6-year limitation period. If you delay for more than 6 years after you have the right to issue a claim, then you are vulnerable to a limitation defence. You lose your right. So what did Inder do? Well, two things he did. Firstly, he got the permission of the court to bring what's called a derivative claim. This is where, in exactly this situation, there's a deadlock. The party wanting to bring the claim doesn't have sufficient control over the company's board. The shareholders can get permission of the claim permission of the court to effectively bring a claim via the company, even though it's not supported by the majority of the directors. So the court okayed that, and because there was no point suing Torex, he claimed against Jat in his personal capacity for breaching his fiduciary duties. You remember, Jat was the one who caused these payments to be made in the first place. Jat defended it. He again went to, his first defence was that the payments were loans, and on the fact that wasn't made out, there was no evidence to show that there was an intention to repay them. They simply paid the money across to his other company, Torex. So the court rejected that. Jat then said, well, okay, I should have the benefit of Section 1157. And that also failed. On the evidence, he was plainly in breach of his fiduciary duties, and he couldn't be said to have acted honestly and reasonably, so he shouldn't have any relief under this section. Then got worse for Jat, because these payments had been made in breach of trust, and trust is unusual because the normal 6-year limitation period doesn't apply, and that allowed the two companies that run through Inder to claim for a longer period than the normal 6 years, and all of the payments could be recovered. So that the court ordered Jat to repay all of the cash that had been taken and interest on that. My final case that I'll talk about in the context of fiduciary duties is this one, BTI 2014 and Sequana. This is actually an enormously complicated piece of litigation. The full judgment is about 173 pages long. So for today's purposes, I'll very much simplify the facts. AWA was a company that was a subsidiary of Sequana. It had substantial, but at the time unquantified, environmental liabilities. Now, the directors of the company knew that there were liabilities, but they didn't know how much they were. exactly how much they were, because it was impossible to do that. They made a reasonable provision in the company's accounts, and the company was, on that basis, solvent from a balance sheet perspective and also a cash flow perspective. It didn't have any unpaid creditors at the time, and the AWA declared two substantial dividends. The first one was in December 2008, and the second was in May 2009. So these are payments up to its parent company, Sequana. It turned out that the liabilities are much greater than expected, and a company had a benefit and indemnity. The claimant company had a benefit and indemnity, and brought some claims. And the claims were twofold. The first was against the directors of the company under Section 172 of the Companies Act. And you remember that I mentioned this a little while ago, and this is the duty to promote the success of the company. And there was a long list of things that the directors must take into account, but in some circumstances, they must consider the interests of the company's creditors. And the second claim was against Sequana. This was the recipients of the dividend payments under Section 423 of the Insolvency Act. This is known as transactions defrauding creditors. So if a company at any time enters into a transaction for less than its true value, and it does so with the intention of putting its assets beyond the reach of a creditor or a potential creditor, then the court can subsequently reverse that transaction. So what happened when it got before the judge? The claims against the directors were unsuccessful. As I say, that on the basis of the filed accounts at the relevant time, there was a positive balance sheet, there were no unpaid creditors, and on the facts, the interests of the creditors under Section 172 were not engaged. They'd satisfied their other duties as creditors, and they were not liable personally for that claim. As less relevant to today's session, the Section 423 claim did succeed in relation to the second dividend. Remember, there was one from December 2008, and the second was May 2009. By the time of the May 2009 dividend, the likelihood of liabilities was a little bit higher, and that was sufficient for this to be a transaction defrauding creditors, and Sequana was ordered to repay $138 million. So the lessons we can draw from that. The Section 172 claim failed in these particular circumstances, but it was confirmed before the court that a company's insolvency is not essential to show that the creditor's interests will be engaged. In other words, it's not just if a company goes bust does a director have to take account of take account of the creditor's interests when making decisions. If the company is nearing insolvency, although not quite there, they will have to take those interests into account, and they fail to do so, they potentially incur personal liability. The second point, which is interesting from a lawyer's perspective, and again, it's possibly important for a board to take into account when declaring a dividend. A dividend is capable of being a transaction defrauding creditors. So if a company were worried about a potential claim, think, well, we'll put all our cash beyond the reaches of that creditor by declaring a large dividend. That is potentially reversible later on if it can be shown that the true reason for it was to put the assets beyond the reach of the creditor. Okay, moving on to a different theme now, and this is the duty to act reasonably. It's not a particular duty under statute. This is one that was found in a contract in the case of Watson and Watchfinder. The claimant here was a business development consultancy, and it entered into a contract with Watchfinder, it's a company that deals with and sells pre-owned watches. The relationship was fine at first, and there was a service contract and also a share option agreement between the claimant and Watchfinder. And the share option agreement had the wording in italics there. The option may only be exercised with the consent of a majority of the board of directors of the company. Unfortunately, the relationship soured and came to an end, and the claimant purported to exercise the share option. The company said, no, you can't. We've got an unqualified right to reject your share option claim. We don't have to give it any consideration at all. There's nothing in the wording there in italics that requires us to give it proper consideration. So the answer is no, you can't have your shares. Watson sued, and this is what happened. The court decided that there wasn't an unconditional right of veto, as Watchfinder had claimed, although the contract didn't say that there was a duty to exercise the option in any particular way. The court implied a duty not to exercise the option unreasonably, capriciously, or arbitrarily. And moreover, that duty was breached because there hadn't been a proper discussion at board level. The whole board hadn't been involved in the decision-making process, and they hadn't been given all the relevant information. It was treated as a fait accompli, and and Watson's claim under the share option was rejected without having a proper hearing. The court went on to decide that had there been a proper consideration of the claim, then it would have been granted, and Watson won the case as a result. Again, there are some lessons that a board of directors can learn from this. Watchfinder lost because it didn't give proper consideration to the claim, and had it done, we'll never know, of course, but had there been a properly constituted board meeting with all the relevant information put before the board, and the board then rejected the claim, it's quite possible the court wouldn't have interfered. This situation applied specifically to the exercise of a share option, but I don't see any reason at all why it couldn't be used as authority for other decisions where the consent of a board of directors is required, and I expect the court to similarly imply into those decisions a duty to act reasonably. So this emphasises the importance of a board of directors taking decisions at properly constituted board meetings with minutes taken and all the relevant information being before the board. Next issue I want to talk about is personal liability for the acts of the company. This is an interesting case, Victoria Plumb and Victoria Plumbing. It's actually of most interest to intellectual property lawyers, but there is something that's helpful for people interested in directors' duties. Both the parties were online bathroom retailers, and what they did, they paid for Google AdWords in each other's names. So, for example, if a consumer searched for Victoria Plumb, they'd be taken to results for Victoria Plumbing, and vice versa. And they sued each other. They did it in slightly different ways. Victoria Plumb alleged that Victoria Plumb was guilty of trademark infringement, and Victoria Plumbing alleged that Victoria Plumb was passing off, which is a legal way of saying that they were pretending to be them. They both won, unsurprisingly, but the case went a little bit further because Victoria Plumb alleged that Victoria Plumbing's managing director and shareholder should be jointly liable under the judgment. Of course, the starting point is companies have limited liability status. Directors can benefit from that, and a claim, a judgment against a limited company will not be enforceable against its directors and shareholders. The test to get around that, what the claimant had to show, was that the director had assisted in the commissioning of an act. It was pursued to a common design and is or turns out to be tortious. It's rather legalistic wording there, but what it suggests is that the director was personally involved, he had an interest in the outcome of this, and the act was wrongful. So the court considered the test and came to this decision. The MD and shareholder wasn't liable in this case because he wasn't personally involved. His involvement was at too high a level. He accepted that he had ultimate responsibility for the actions of his staff, and he might have even been involved in, is aware of what some of them were doing. But because he wasn't personally carrying out the offending acts himself, that was insufficient for him to incur personal liability for the actions of his company. The implications here, it's something that should be of comfort for directors in general, and also a note of caution for anyone claiming against the company and saying, well, can't I go and sue the directors as well? No, not in general. The principles of limited liability remain very much in play. If you want to go behind it, you have to show a very close personal connection between what the individual director and shareholder was doing and what the company itself was doing. Okay, it's an interesting case involving a director, and for today's purpose, about the settlement of claims. This is our Office of Technologies and Anthony Mike. Office of Technologies Limited was a company that was described as the lunch at work business. So I think they're catering for offices. It expanded very rapidly and was at one point thought to be worth quite a lot of money. It ran into cash flow difficulties, and in October 2016 was served with a winding up petition. In December 2016, the director of the company and the defendant was subject to various disputed allegations, but as a result, he was removed from his office as a director employee, and he entered into a settlement agreement with OTL. In February, so 4 months or so after the winding up petition was served, the company OTL entered into liquidation, and the liquidators brought a claim against the director, and they also alleged that the settlement between the director and OTL in December 2016 was void under Section 127 of the Insolvency Act. What Section 127 provides is that if there's any transaction that's entered into after the commencement of the winding up, and for this purpose it means when the winding up petition was presented, so on the facts in October 2016, any transaction entered into by the company after that is void unless the court orders otherwise. So the court had to consider a couple of points. Firstly, did the settlement agreement, remember of course that the company had already settled its claims reportedly with the director, did that prevent the liquidator making further claims against the director? And secondly, even if the liquidator lost that point, could he say that the settlement it was void, it had no effect because of Section 127 of the Insolvency Act? And the liquidator actually won both points. Only need to win one, but they won on both grounds. And the reason for that is the director, he gave up his claims against the company in his capacity both as director and as employee. The company only gave up their claims against the director in his capacity as an employee. So it left open the possibility of claiming against him as a director. But the court said even if they'd found against the liquidator on that basis, the settlement would have been void because of Section 127. Generally, when we talk about Section 127, we think about payments that a company makes between the presentation of a winding up petition and the winding up order being made. But the court's helpfully explained here that it's wider than that, and what we call lawyers would call a cause of action, the right to bring a claim, and giving up that right to be a claim will also be considered a disposition of assets. You're giving away that asset, and if you do so, that's also void under Section 127. So the lessons from this case, firstly, the claim against the director was allowed to continue because there wasn't a waiver of claims against him as a director, as opposed to a waiver of claims against him as an employee. So whenever documenting a settlement, it's very important that you cover all of the claims that you intend to. And the second thing to bear in mind is the wide-ranging nature of Section 127. So whenever a winding up petition is served, be very conscious of the scope that the court later has to set aside transactions beyond a simple payment of money. Want to spend a little time talking about two recent wrongful trading authorities. And the first is the one of Brooks and Armstrong that involved a Robin Hood theme park. Before I do so, I'll just cover what Section 214 involves. This is the wrongful trading test. It's a claim that can be brought by a liquidator or an administrator if they can show that the directors of the company, they knew or they should have known that there was no prospect of avoiding insolvent liquidation. If the directors did know that, and they didn't thereafter do all they could to reduce the losses to the company's creditors, the court can order that the directors will be contribute personally to the company's losses. Generally, this is understood as doing all you can to avoid losses is shutting the door, closing the company immediately, and if you carry on trading, that's when you put yourself at risk. And the two cases I'm going to mention addressed exactly that. This is the Brooks and Armstrong Robin Hood case. It has a long history, and it was very complicated by the time it came before the company's court. The liquidation started in 2009. The liquidators say that the directors should have ceased trading sometime before that. The liquidators issued proceedings in 2012. The case didn't go to trial until 2015. The liquidators had limited success. It was quite a long hearing, a long judgment. The liquidators were awarded £35,000, or the directors were ordered to contribute £35,000 to the assets of the company, but reflecting the fact that the liquidators hadn't been particularly successful, there was no order made as to costs. And what's recorded in the appeal judgment, the liquidators' costs at that stage were £1 million. So the liquidator appealed, hoping to get a better result on costs and also on the amount that the directors would be ordered to contribute. The directors cross-appealed and said they shouldn't have been ordered to pay anything at all. Now, when it came before on the appeal, there were two issues that the court needed to consider, and they defined them as the knowledge condition and the minimising loss condition. And this is linked into what Section 214 says. The first point about the knowledge condition, this is when you knew or you ought to have known that there was no prospect of avoiding insolvent liquidation. So the court will look at a particular stage in the process and say, okay, from that point, you knew that there was no hope for the company. It was inevitable that it was going to go bust from that point. So that's the sort of line in the sand that's drawn, and what's the knowledge condition. From that point, you go on to consider the minimising loss defence, and this is, did the directors from that point onwards do all that was reasonable to minimise the loss of the company's creditors? As I say, in most circumstances, that will be interpreted by directors as ceasing to trade. In this case, that's not what the directors did, and they continued to trade. And the court on appeal said that was fine. I said the registrar's decision was mostly upheld. What I mean by that is the liquidator's appeal was rejected and the cross appeal of directors was successful. The order that they contribute £35,000 was set aside, and they didn't have to pay anything to the liquidation of the company. And the reason for that is by continuing to trade, they actually turned a profit for a period of time. Continuing to trade was a net benefit to the creditors, and had they closed the doors immediately, they knew that there was no chance of the company not going bust. The creditors have actually been worse off. Or put it another way, the liquidators had failed to show that there was a detriment as a result of the continuing trading, and for that reason, the directors weren't ordered to pay anything at all. There's another case called Granted Rules, which I won't deal with in as much detail because the facts of it are very similar. This was actually a construction company. There was no dispute that the company was insolvent, so what was referred to as the knowledge condition in the previous case was satisfied. The directors knew or ought to have known that the company was insolvent, and so the court had to go on and consider what were the consequences of continuing to trade. And again, the liquidators here failed to establish that there was a detriment to the creditors by continuing to trade, and in all the circumstances, it wasn't right that the directors should be ordered to contribute to the company's losses. Now, a couple of things I draw from that. Wrongful trading claims in practice are quite often threatened. They're not actually issued very often. There are various practical reasons why it's difficult for liquidators to bring these claims. I think these two cases will make it even more difficult, and we'll see wrongful trading cases even more infrequently. But it's important to bear in mind when thinking about these claims that insolvency isn't everything. It's not sufficient just to prove the knowledge condition, as the court put it. You've got to think about the implications of continuing to trade. From a director's perspective, it's very important to keep records. It's always important, but these cases just reflect that. And two things about that. Firstly, to keep proper financial records so that you can show that by continuing to trade, there was actually a net benefit to the company. And secondly, to keep a clear record of why you took the decisions you did at a properly constituted board meeting with minutes. They were the cases I wanted to cover today. I'll just finish by mentioning very briefly two possible things on the horizon. You may have seen right at the start of the year the deferred prosecution agreement that Rolls-Royce entered into with the SFO, or also with the SO's equivalent in the US and I think Brazil. If you haven't, look it up. It's the figures in it are quite staggering. Rolls-Royce was agreed a fine of £671 million as a result of its very wide-ranging involvement in bribery over many different jurisdictions over a long period of time. Now that's all very interesting from a corporate perspective, but what the deferred prosecution agreement, the DPA, kept open was the possibility of individual prosecutions against directors, and the SFO indicated an intention to pursue such claims. The wheels of justice move quite slowly, and I'm not aware of anything that's happened as a result of that. But equally, I'm not aware that they've been dropped either. So it's something that may be on the horizon next year. Same as a possible thing that's coming up that was fairly high profile was the charity Kids Company, which collapsed in 2015. On 31st of July this year, the notice was given that there was an intention to bring directors' disqualification prosecution against the directors of the company. Again, I'm not aware that anything has happened with that yet, but it's a high-profile issue that may come back into the headlines next year. Well, that brings us to the end of today's session. I hope you found it of interest and some use in your day-to-day life. As a reminder, the webinar I gave earlier on more general directors' duties is on our website if you'd like to see that. We also have various guides on the Directors' Duties tab in our website, so I invite you to take a look at those. If anyone has any questions arising out of today's session, I'd be delighted if you send me an email or give me a call. My details are up on the screen there. So thank you very much for watching, and goodbye.